everybody. I'm Deborah Pagay. Welcome to Winning with Deborah, where people turn to learn. Do you own anything of value, a checking or savings account or coin collection, a special piece of jewelry, an insurance policy, a house? If you answered yes to any of these questions, then you have an estate. Now, many people erroneously think an estate is a large expanse of land with a mansion on it. But legally speaking, estate refers to an individual's total assets. So whether many or few, you need to plan for what happens to those assets once you transition to heaven. This is the essence of estate planning. It is a subject that most people are confused about, but not after this program. So get ready to take detailed notes. My guest today is attorney Caprice Collins. She is founder of the Collins Law Group in Inglewood, California. She's a seasoned and highly regarded Harvard Law School trained estate attorney. She makes the topic of estate planning easier to grasp than anyone I've heard. She's here to debunk some of the common myths surrounding this process and to inform you how to make wise decisions about how to distribute your assets. Welcome, Attorney Collins, to Winning with Deborah.
Good morning, Deborah. Thank you so much for having me this morning.
Oh, thank you. And I just want to thank you straight up for all those free seminars that I've attended that you've given, not only to the community, but even a group of professionals that you've had come to your beautiful office in Inglewood. And I just think you're a blessing to the community. So thank you very much. Well, now listen, we're going to get started with, I'd like to get started with maybe a biblical basis for what we're talking about. And in Proverbs 13:22, it says, "A good man leaves an inheritance to his children's children." What do you think about that?
Well, I think that's really the essence of estate planning, in the sense that we have to think about those people we want to benefit, and that it does require conscious effort in order for that to happen. Yeah. Estate planning is complicated. It involves both state and federal law. So we can't leave it up to chance if we really want to benefit not only our children, but perhaps other generations to follow.
What percentage of the population, I know this is a wild guess, but would you say what percentage of the population really has enough chutzpah to really do estate planning? Do most people do it?
Only 30% of Americans have done any form of planning at all.
Wow. So that spells confusion later, doesn't it?
Yes. And I don't think it really involves how much you have. I have many clients who have comparably little in comparison to others, but they have more of an intent to make their family better off when they're no longer here.
Okay, because I've been through a lot personally, a lot of trauma behind an intent to plan well, but it just didn't happen that way when my father passed away a few years ago. So I'm really interested personally in today's topic. And you're here to debunk some myths that we have about it, because people have assumptions. And just last week I was talking to somebody whose parent had passed away, and then there's the sibling passed away, but his children now have, obviously you know this, have a right to his part of in the estate. And the other siblings didn't understand that. They said, what do grandchildren have to do with anything? So I know we're going to get to that, but so let's just jump right into these myths that people have about estate planning. Now, here's the first one. As long as I have a will when I die, everything will work out just fine. Well, that sounds pretty good.
Well, in our state, what you're planning for is to go to court.
Really?
Because in this state, in order for a will to be effective, it has to be approved by a court. And also, wills generally only leave things to the first generation. So planning for perhaps your grandchildren, planning for people who might have special needs are not effectively done in a will. The other thing I really want everyone here in the audience to understand is that estate planning is not just about what happens when you pass away. It's much more important to understand that it's also about what happens when you slip and fall, have a sudden disability, maybe, unfortunately, develop Alzheimer's or perhaps have a stroke.
Oh, okay. So now a will, but as a minimum, everybody should have a will. And I want to talk to you about that, because you just said that when you have just a will, that's just, you're planning to go to court.
Yes.
And so explain that word probate.
Well, because only 30% of Americans have done any form of planning at all, we have to have some process to be able to move things that are owned by a decedent to a living person. And so that's what probate or succession, depending on what state you're in, is about. It's about moving things that are owned in the name of a decedent to their next of kin.
So probate then is a legal process that we go through to sort of validate the will and say, yes, it was indeed valid. This is what has to happen, and there's a way around that, and you're going to talk about that later. But for the most part, but as you're saying, most people don't even have the will.
Correct,
Okay.
and that process is very expensive. That process will end up losing the family thousands and thousands of dollars, and it doesn't really take care of all of the considerations that most families have.
Yeah, I'd like you to kind of give an example of that, because I understand that, especially in California, when you go to court and there's a probate process, there's a fee. There are fees that are set by California statutes that says, okay, this is going to cost a certain percentage of the estate.
Correct.
Okay.
So these are statutes that you can't get around,
Okay.
related to the gross value of your estate, which unfortunately includes things like mortgages.
Okay.
That really shouldn't be included in evaluating what you're going to get.
Okay, so I'm going to give just a really tired example here. But let's say somebody left you a house and it was $200,000, but you don't have any cash. You just, you were just a poor little niece or whatever, but it was $200,000. It was in the will, and you have to go to court. So this court process is going to cost you probably, what, 5% of that, 3%?
No.
Just make up a number.
Actually, unfortunately, because of multiple fees and charges involved in this, it'll cost anywhere between 15 and 25% of the value of the assets.
Okay, so if I don't have 15 to 20%, if I don't have 20% of 200,000, which is, what's that, $40,000? So I'm going to lose my inheritance because I couldn't come up with the money.
Right.
So I'm going to have to sell that house.
Well, what's even more tragic is that it's based on the value of that asset. But if your aunt left you that property and she had a $100,000 mortgage on it at the time, how many people get property free and clear? At least not that many nowadays.
Okay.
The court determines the price that the family's going to pay or the amount of the cost on the value of the property, not the real equity. So you're only going to get $100,000, but you might have to pay $40,000.
Oh, wow.
To get that 100.
And then you're going to have to sell, you're going to have to sell it because you don't have any cash.
Correct.
I know you understand that. Okay, so that's a myth. And so most people then typically can even lose out significantly if you have to go through this probate process. But let's just deal with another myth too, that if I have a power of attorney, that would take care of all of my problems if I become disabled, if I have a power of attorney.
Well, powers of attorney are only effective while you're alive. So that's important to know, because a lot of people believe that, if I gave you my power of attorney and I pass away, that somehow you'll be able to use that document after I pass away. So
But it dies the day that I die.
correct, okay? And there's two different kinds of powers of attorney. There's one that involves your financial accounts, and we call that a financial power of attorney or durable power of attorney. And that basically would allow you, if I gave you my power of attorney, to handle all of my financial affairs, to be involved in my assets and my debt, and to manage that for some period of time. Now, there's very, very high fiduciary responsibilities in all states, meaning you have to be very honest and you have to take in consideration my needs and not your needs. But that only covers things involving finances.
Oh, so a durable power of attorney only covers finances, not health care, any of that stuff, just finances.
Exactly.
So you got to really know and trust the person that you give that ability.
I will tell you, that is the hardest decision. That is the most important decision that any of you can make, and that is to make a very good determination of who you trust, and to make it on the basis of what you've seen a person do with their own assets. How have they conducted themselves during their lifetime? Are they honest? Are they prudent in the way they manage things? Do they go to professionals when they need help? Do they go to an accountant or perhaps a lawyer or some other person when they need help? See how they've handled their own affairs, how they may have been involved with other family members, and make your decision on that. Unfortunately, a lot of our families make a decision just based on family relationships.
Now, I was about to say that because in my case, my brother, who's now deceased, but he felt that he should have been, I was the executor of my dad's will, but he said, I'm the oldest. And now, is this cultural? I mean, do minorities tend to focus more on the relationship? I'm not just trying to paint a broad brush, but is that cultural?
No, I think it's really what most parents feel. They want to be fair. They want to be fair with their family members. They think that if they don't include everybody or people in that kind of order, the eldest to the next, that they are somehow disrespecting or being unfair or showing lack of confidence in the child. But that's not where you do that. In other words, if you want to really show the love you have for someone, you do it in the distribution. In other words, how do I distribute what I leave?
Okay.
It's really important, ladies and gentlemen, for you to understand that when you make someone your power of attorney, they would have the right to sell your real estate.
Yeah.
They would have the right to mortgage your home. They would have the right to get you into legal contracts that you might not want to be gotten into. It's very important to understand that it requires someone who has shown you by the way they handle their own affairs that you can trust them with yours.
So what's the worst you've seen? I know you have a horror story you can share with us. Have you seen one that's just like one for the storybook?
Well, I think the worst we really see, Deborah, is the lack of planning. And I'll tell you, this is a concern that all of us have in many, many areas, and I know you as a professional see this too, and that's elder abuse. And we're seeing a large amount of elder abuse occurring in all communities.
Because they trusted the wrong person?
No,
Maybe
often because they didn't trust anyone, and they didn't put anything in order.
See, and I think it's the parents' fault that we have a lot of turmoil after they die because they chose the wrong person. I hate to say that, but it's like you could have made this easier. You chose the oldest or whatever. That person had no skills, in this area. So I'm thinking, or just historically, they've not been a really good money manager. But I'm just wondering, how would a parent have that conversation to sit all the kids down and say, listen, this is what I want? But we'll talk about that in another program because I'm going to have you back. Okay, let's look at then this whole idea of a conservatorship. What is that?
Well, we call it here in our state conservatorship, but in most states it's called guardianship. And what guardianship basically means that the court at some point determines that a person, because of mental or physical disability, can no longer handle their own affairs. So we see it even with husbands and wives, where unfortunately maybe someone has had a stroke, developed dementia, had a serious accident, and they can no longer write, they can no longer speak, but you have ownership of real property or other kinds of assets that need to be managed. To be honest with you, in most cases of conservatorship, we're seeing people that are being subject to elder abuse.
Now, isn't that kind of a humiliating process? Because don't you have to go to court and take that person with you? And they have to show that that person has no real mental capacity to be able to handle their affairs. And I've never been to a hearing like that, but I mean, the person comes, right?
Yeah. Well, no, the person doesn't have to be present.
Okay.
But there has to be legal documentation, declarations, affidavits from their physician. So it is humiliating that you had to declare someone you love to be incompetent in order for you to protect them. But most people do conservatorship or guardianship out of love. That's really what they're doing. They're doing it because they see mom or dad being taken advantage by someone. Could be another person in the family, unfortunately. It could be a professional, unfortunately. It could be a caregiver. That's what we see, unfortunately, a lot of, too.
Okay. Well, that's bad. That's a really bad thing. But how can you avoid a conservatorship? Now, what could that person have put in place? Would a power of attorney have avoided that person having to resort to being put into a conservatorship situation?
I think it's a lot more complicated than that.
Oh, really? Okay.
Okay, and this is where I think the real issue is, are you involved with your elder's life? Okay. Do you visit them? Do you observe them? Do you really know what's going on with them? Okay. Do you take the time to go to the doctor with them? Do you, when you see something unusual in their home, you see a pile of bills sitting on the table, and you're not really, understanding what's going on? Speak up.
Okay, and we're going to explore that whole idea in a subsequent show that I'm going to do with you of elder care and that kind of thing. Now, let's look at a third myth. Joint tenancy is the best way to hold title to my property. Joint tenancy. Now, you can explain the opposite of joint tenancy, because there are several ways you can hold title to property, whether you're married or single. So what's this idea of the myth surrounding joint tenancy?
Joint tenancy only works when somebody dies. That's what we have to understand.
Okay.
So while, yes, if you held it with a husband and unfortunately you lost him, yes, you would become the full owner of the property. But unfortunately, what joint tenancy doesn't do, and what people don't realize, is that way before somebody dies, you may have a need to manage their affairs. And so if people think that joint tenancy will allow me to manage my husband's interest in this property or my wife's interest, they're incorrect. When you have a joint tenancy, you're basically saying that both of us are going to own this together, half and half. We will be making all decisions together as relates to whether or not we sell it, borrow on it. And we have to be able to make those decisions. We have to be able to sign or to be able to verbalize an agreement.
Oh, I see what you're saying. I think I'm just getting this. Because I know joint tenancy is like winner take all when somebody dies. The whoever survives, the ownership automatically goes totally to that person. You don't even have to go to probate for that, right? If you hold it in joint tenancy, you don't have to go through that probate process. I didn't think about the fact that that would be an issue other than dying. Okay.
Exactly.
Okay.
And what we unfortunately see is people holding joint tenancy with people they really shouldn't be. I see a lot of parents holding joint tenancy with their children. Yeah, or even non-related parties. And often they'll say, well, you know, Ms. Collins, I just thought that, you know, when I died, like you said, my daughter or son will get what I had.
And that's a good thing, right?
Well, that's fine.
Right.
Unfortunately, when that daughter or son gets divorced, guess what? Half the property belongs to the child. And now that divorcing spouse has a right to one half of your property. In addition, if that person got into any kind of debt or creditor or a dispute where they owed money for, let's say, unfortunate auto accident, tax lien.
Oh my goodness. So what's the opposite? How should they, tenants in common? Is that?
No.
No, what?
You
What's
should
the best way?
never, ever put someone else's name on your property, period, unless they own it with you. So when you and your husband go down and purchase a piece of property together, that's the way you will put it in joint names. But you don't put things in joint names believing that that's the proper way to leave it to my child at the end of my life.
Your goal may have been to avoid probate and all that and save all those fees, but you created another problem. But what is tenants in common? That's a way to hold title to property. Is that good?
We have lots of different ways. So if you're a single person, even if you're not a single person, you could hold it. Deborah, an unmarried woman. Deborah, a married woman, is her separate property. You can own it in what we call tenancy in common, which means that we own it jointly, but I don't get what you have when you pass away. You don't get what I have when I pass away.
When I pass away, my heirs will just get my part. The title doesn't go, So if you and I bought something together, let's say you and I bought this big, fabulous apartment building together, how would we hold that?
We would probably hold it in an LLC partnership.
Leave it to an attorney to complicate it. Okay, let's look at another myth. Myth number 4, leaving my property equally to all my children at death is the best way, leaving the property equally. Now, if you have 6 kids and you say, okay, I want them all to have title to it, tell me the pitfalls with that.
Well, you're probably looking for a disaster.
Really?
Yeah. This is typically what you see in what we call heir property. We'll often see, particularly in past generations, where a family member will have put all of their children's names on a piece of real estate, okay? And this happens when you have probate and you, let's say, have a single piece of real estate and you have 6 children, then they will all become owners of the property. But there's a lot of reasons why that's not a good thing to do. First of all, you need to evaluate the situation of each child when you make decisions about who's going to get what. You need to understand that perhaps a person who has a disability already, someone who's already receiving government benefits, that their interests would really be attached by what we call recovery, meaning that they wouldn't even get it, perhaps. Or if they inherited from you, they may not continue to get their government benefits because they will probably not qualify anymore for them. So, you know, it could be a worst case scenario where you have a child that's, let's say, has multiple sclerosis, is receiving a basket of benefits. Those benefits are really providing for them and their family, and then all of a sudden they inherit a 1/6 interest in a piece of real estate. Now they lose their benefits because they have no longer the qualification to receive it.
So what's the best way for a parent to leave property to several children at once? What's the ideal way?
Well, in that kind of a case, you might leave a different asset to that person, or you might go ahead and leave what we call a special needs trust. And that's something that's very common in families where we have children with autism or even children with, let's say, addiction.
But if they're just all healthy people who just get greedy when somebody dies. That's another whole show.
Yeah.
It brings out the worst in people. But if you have someone who has 6 siblings and the parent, how should the parent have left that asset?
Preferably, they should have left it in a living trust, and they should have indicated what they wanted to happen with that asset. And often nowadays, my clients will say the asset will be sold at my death. Because when you have
I think they're smart. I think they're smart.
And I'll be honest with you, there's a rare instance where you have 6 people where one person isn't living in the property.
Yep.
That's a big complication. Often that person has been caregiving for the parent. And now you have a person who feels entitled to the property or more than their 1/6 because they've been there.
Yeah.
And so there's just so many different complications that can come, but to get all 6 people, let's say, to continue to support that property, pay the taxes, the insurance, and the maintenance.
I'm right in the midst of that situation, so I'm glad, I hope everybody's watching in my family so that we can hear from a real live attorney that I'm not making this up, yeah.
It's just leading to family drama. So when you sit down with someone like an attorney who does this every day, they know what happens when people pass away. They've seen it all before. And they advise their clients of the various solutions, various alternatives. You know, it's not one size fits all.
Yeah. Now, you mentioned earlier that a living trust would have been the better thing to do. Now, talk about that, because we didn't talk about that when we talked about a will, because I want to ask you 2 things about that. You can have a will, or you can have a living trust, or you can have both. Now, who needs a living trust?
Anyone that owns real property. They absolutely need a living trust. Anyone who wants to provide beyond the first generation. So your wonderful scripture that you began with about leaving something to your children's children really does take planning. And you can't do that with a will.
Okay.
You can do that with a trust where you will decide, let's say, for instance, that I want to help my grandchildren have a college education.
Okay.
I want to benefit a wonderful nonprofit, a faith-based charity. All of those things can occur when you have a living trust.
And you don't have to go through probate.
Exactly.
Because the assets can just pass within, it's a shorter period of time, because with a will having to be probated, how long is that probate process? That can last, I was in court like 2-3 years for my uncle's death, so.
That's about average. That's about average. But it could be a lot longer, unfortunately, when we have what we call family drama and we have people fighting each other over things, then it can be years and years.
Okay.
However, with a living trust, technically, you could actually do distribution 120 days.
Wow, after the person's death.
Yes.
Okay. Now, suppose you don't have either one, just come on, give us some secrets. I know this doesn't help the profession, but there is one more option on certain assets that you don't have to have a will or a trust.
Yes.
You can have designated assets. Now, tell us about those.
Okay. So what you're talking about is pay on death beneficiaries.
Yes, pay on death beneficiaries.
And when we open any financial account, we are asked for pay on death beneficiaries. So whether it's a bank account, or it's an investment account, or it's an IRA, or it's an insurance policy, we must, in order to complete the contract with the financial institution, indicate who would receive it at our death.
So if there's a named beneficiary, then there's no need to go through the probate process.
That's correct.
That's a good thing, because I advise some people to, you know, especially with cash, because sometimes you need money to pay for the funeral, and if it's not a person designated or whatever, then you're gonna have to just wait and, you know, borrow the money or whatever. But if you have this payable on death thing assigned or whatever, then they can just get the cash once they present the death certificate, right?
Right.
And then they can get the cash and pay for the funeral.
Right.
Or blow the cash.
Yeah, there you go. And, you know, and unfortunately also, you know, if you would like to use that kind of a policy, so let's say an insurance policy for the benefit of a child or someone, you'd want a trust where you could set the parameters. Do I want my grandchild to receive from me even if they're having drug or alcohol issues?
Okay.
Do I want to support that kind of behavior, or do I want them to support them going to some kind of institution for higher learning? So the real ability to do what your scripture said, which is to leave to our children's children, takes planning.
Yeah, planning. Now, but here's the deal. There's a cost involved, and I'm thinking that most people don't do a trust because a will you can just write. You know, you can handwrite that, right? What's that big word they call a handwritten will?
Let me just say this: that what you're really doing is you're first planning for yourself. Are you worth the attorney services to make sure that, let's say, for instance, if you got in a serious automobile accident, that the right person would be there to manage all that you are, your physical being, all of the things that you're doing,
And you
all
can't
your
provide
assets.
for that in a will.
No,
That just doesn't.
yeah. So
Okay.
it takes a number of documents. It takes a trust, powers of attorney for finances, and for healthcare decision making, which is a very, very big thing. If you want to, if you have a minor child, you do need to have a will. That's where guardianship of minor children.
Because you can't leave assets to a minor.
No, no, they would not be able to receive them until they're 18. But that's dangerous too.
Okay.
Because let's say you do leave something to a grandchild who now is 16, and then when they become 18 in the state, they become actual legal adults. They would receive the entire benefit. Let's say it was a $250,000 life insurance policy, all at one time.
Yeah, that's bad.
Yes.
And in a trust, you could have provided for them to get so much per year. I think that's important. I think that's important. You know, I think with this will versus living trust thing, I think it's like pay now or pay later. So if you so if you get a living trust, you pay now, and it's, you know, the fee is like horrendous, but it's a fee. But if you have a will, you're going to pay later, and it's going to cost you a lot more, isn't it? Because you're going to have to pay that $20,000 to $25,000 you talked about earlier. Whereas if you had gotten a living trust for $2,000 or $3,000 or whatever the number is, then that would have been smarter.
Well, I think it also goes to legacy. Are you really interested in leaving a valuable legacy to your family? And that's the difference between a will and a trust.
Okay.
With a trust, you can leave a legacy.
Okay, so if you had to have some last words or whatever, what would you say that people should really be mindful of? And just take your time and speak to what the things we need to make sure we're mindful of.
Well, I think you should be mindful of that everyone right now has a plan. And I know many of your listeners and your fans would say, what does she mean, I have a plan? She doesn't know me. Well, the reality is there's only two things. One, we can actually make our own plan and then determine our destiny and perhaps the destiny of our family. Or we can let the state have the plan for us, because whether we like it or not, there is a plan in force right now for every person who fails to plan. And most people don't know what that is, and nobody wants that to be their plan. So understand, you have a plan now, it's your choice. It will be yours or the state that you live in. Well,
you know, and I'm glad you mentioned that thing about the state, because there is what they call a succession, intestate succession. Hope I said that right.
Yes,
if you die without a will or whatever. Right. And I find this interesting, because they will say, okay, here's the next person in line to get your assets. And it may be somebody you don't even like, somebody that, but legally it's what it is. It may be your, I think, what is it, a husband is a spouse, then children, children, then a spouse in California. What is that order? Just tell me that briefly.
It is. Your spouse is entitled to 50% of your estate. Then your children would be entitled to the remaining 50%, and their children may be entitled to the percentages of each individual child who has become deceased, and it goes on and on by a bloodline.
By a bloodline. And I know that there's a priority of bloodline, because I think next would be your parents before your siblings.
Yes.
Yeah, so it's just too complicated you just need to plan so that you can go in.
And who knows who will be alive at that time.
Right, and have your wishes.
That's right.
Gosh, you've been great. Thank you so much for being here. I'm sure our audience has been empowered, and we're going to talk in a subsequent show about elder care and some more things we can do so we can tighten this area up and be good stewards. Well, thanks for joining our discussion today on estate planning. I believe you now have more clarity about this important topic. And remember that when you plan your estate, you are providing for the people you love. And in doing so, you minimize, not necessarily eliminate, but you minimize conflicts and tension after your death. Surely you want to do that. Trust me, you want to do that. But you have to do it wisely. So this kind of planning, it will be your last act of good stewardship. And also consider the values and the habits of the people that you decide to turn God's assets over to. You want to consider including the work of the Lord in your distribution and the role you'd like to play in seeing that work continue. But most of all, learn to enjoy some of your resources now. Don't save everything. Your quality of life today matters to God. Well, that's all the time we have for today. If any part of this program has ministered to you or impacted you in any way, I'd like to hear from you. I'd like for you to go to my website, Winning with Deborah, where you can read book excerpts from my various books I've written on finances. I have a book called 30 Days to Taming Your Finances, where some of these principles are there. And there will be other information there that will enhance your spiritual walk. So thank you again for joining me, and until we meet again, have a winning week.